All right, I got to like 6 words or 6 sentences. Jeff Lucas is licensed land surveyor in Alabama, Florida, Georgia, Mississippi, and Tennessee. He's also a licensed attorney in the state of Alabama. Jeff is recognized as an expert in land boundary law, riparian rights, and land surveying liability issues. He has practiced land surveying throughout the 5 southeastern states in which he is licensed. Jeff is also the author and columnist, lecturer, and seminar presenter. He has authored 3 books on surveying. I just had this conversation with somebody in the office the other day. We're missing out on a lot of the Wilsons, the Rubelards, and even like Lucas. We don't have a lot of publishers at the moment right now for going on in the profession. So we need to find our next up and coming publishers for sure. Has over 100 nationally published articles and over 30 titles in his seminar library. Jeff has presented continuing education seminars at conferences, which he'll be at our WestFed conference coming up in March at the end of next month. He's presented in Alaska to Florida, from California to Nova Scotia, and anywhere in between. So you can find more information and purchase his books on lucasandcompany.com. So again, we appreciate your time, Jeff. And I'd kind of throw out in the emails just kind of a precursor, like, the state boards are always changing their laws as well. And so for any licensed surveyor or who those have become licensed, you definitely need to stay up with your own state statutes, your own administrative codes within your association, because there's always some language that they're tweaking. Here in Nevada, we're required, as of a couple of years ago, we have to put on our contracts whether we're carrying E&O insurance policy. Doesn't have to specify the limits, but we do have to put on our contracts whether we carry it or don't carry it. So there's little nuances that from your state board society or state board licensing board that you need to make sure you get on your contract. So that kind of stuff. And then of course, what you'll definitely add in today. So I appreciate your time.
Well, thank you, Trent. I appreciate being here with everybody. Trent, I found out entitled this thing, he took it off my website. Ostensibly, I offer this, the standardized contract for land surveying services. Okay, so truth be told, I haven't developed that one yet because nobody's asked for it except for Trent.
No worries. It was general. It was a general topic.
But I do want to talk about the idea behind that.
Exactly.
And the idea behind that is leveling the playing field for the surveying practitioner. And what I mean by that, well, first of all, it kind of goes back to, and I can't say I'm an expert on their contracts, but the architects have standardized contracts, and it seems like, all the architects, when they hire surveying services, engineering services, or get hired by their clients, they have their standardized contracts. I think something like that would work very well for, pretty well for us. I guess the question would be, how would you initialize that? How would you make that a standard contract? We can't force people to use contracts, but I want to point out some really egregious things that we have going on here in the land surveying profession. And let me share my screen here. Share screen. Let's go with this one. Okay, can y'all see that? It's called a new practice model.
Yes, sir.
I'll go to the, I'll start a slideshow from the beginning. All right, so let's go to the NCEES model law for licensure of engineers and surveyors and go to the basic definition of surveying. And we can get rid of most of it. We'll come down to section 110.20B4, practice of surveying. The term practice of surveying is used in this act shall mean providing or offering to provide professional services. Professional services include information related to any one of the more of the following. And this is the crux of the problem right here. And I should have some tools. How about, and let's see, more tools. Okay, where's my spotlight? Where's my spotter?
Yeah, so this was looking to find the little laser tool or something. Yeah.
All right. Oh, wait, here we go. Maybe this is it. Laser pointer.
There you go.
All right. It didn't turn into a laser pointer over here on this screen.
It's showing,
Okay,
showing
there
up.
it is.
Yeah.
All right, there it is. All right. Practice of surveying. And this is the crux of the problem right here. The practice of surveying, according to this ancient definition that has been around ever since I've been in the land surveying profession, this thing must be 60 years old. The practice of surveying means, and we're talking about retracement surveying at this point in time, okay? Because all of those other things that they have in there are not, we could go through that, but that's not what I'm here to do. I'm getting to the point. All of those other things that they use to describe the practice of surveying is not exclusively for us surveyors. Anybody can do those things anymore these days. Anybody can go out and locate data. Anybody can buy a drone, and anybody can operate a drone as long as they have an FAA license to do it or certificate to do it. So it gets down to C as to what we did, the core issue of what surveying is all about. And just look at this definition, how horrendous this definition is. Locating, relocating, establishing, reestablishing, or retracing. Now, so you have a choice. You can either be locating property lines, or you can relocate property lines. Now, to anybody, just pull out Webster's dictionary, and what the heck does relocating mean? It means move to a new position. Move to a new location. That's what I call deed staking right there. That's, you know what I mean by deed staking. You take a deed, you find yourself, what do you need to be a perfect deed staker? What do you need to precisely stake out the deed? You need a starting point and you need an azimuth, and from there, it's all math and measurement. So what the deed staker is actually doing in reality is relocating property lines. And it's perfectly legitimate. Here it is, right? The definition of surveying. Now, Jeff, you're talking about the NCE model laws. What does that have to do with us? Everybody's boards go by what the NCEES tells them to do. And of course, we know what the problem is. It's that second E. This whole profession is run and has been run by the engineers. Surveying is not an engineering project. So we're going to locate. Now that kind of sounds like retracement. I'm going to go locate property boundaries. But then I can relocate them too. And so I've got perfect cover to go out and deed stake. If somebody calls me on it and they say, hey, you didn't do a retracement surveying, all you did was slap the math on the ground. You're right. I relocated the property lines, and that's perfectly in accord with the definition of surveying. It's perfectly legitimate practice. Now here is where the NCEES, where the ignorance of the NCEES and the people who created this definition shines. They don't know the first thing about how boundaries become established. Surveyors establish nothing. Boundary lines do not become established by surveyors. Surveyors are part of the process, can be part of the process, especially if the surveyor is an original surveyor laying out original lines for a common grantor. You cannot be an original surveyor unless you are working for a common grantor. That is an absolute necessary element. You can't be an original surveyor for diverse ownerships, for diverse landowners. Now they can all join together in some sort of partnership or joint venture, and then they are the common grantors. But if you've got diversity of ownership on both sides of the line, you cannot be an original surveyor. Now, an original surveyor plays a role in the establishment of boundaries, but and the courts, the courts talk about the importance of that original surveyor, but in reality, the surveyor is almost irrelevant. I'm going to say almost, but not totally irrelevant. It doesn't matter what the surveyor did. The only reason an original surveyor becomes an original surveyor is if and only if that survey gets the blessing, gets the sanction, the landowners go in reliance on that original survey. Without reliance of the landowners, the boundaries never become established. That's how boundaries are established, through the reliance of the property owners. And what makes that original surveyor somewhat infallible is the fact that the surveyor put the stakes on the ground, the people moved in, they glommed onto those stakes, and when they glommed onto those stakes, their property rights attached to those lines between the stakes, between the corner monuments. And that's when the boundary line becomes established. Because a very easy, maybe extreme example would be, you could have an original surveyor laying out the lots on a 40-acre tract, and he lays them all out for the common grantor, and then the common grantor finds out that there was a mistake in the topo, and his entire subdivision is 4 feet under the floodplain. So he has to bring in 4 to 5 feet of fill to get above the floodplain, and he completely buries all those original monuments set by the original subdividing surveyor. And then he hires a new surveyor to come along, and because that first original surveyor, let's just say he's out of business, passed along, and now he hires another one. And that one comes out and restakes the entire subdivision, ostensibly in the same exact positions, but we know they won't be in the same exact positions because we're just not we're not there yet. They're in slightly different positions. So who's the original surveyor for the subdivision? It'll be the one, when the people come in and they glom on to those monuments that are there. This is called the doctrine of monuments, or the common grantor doctrine. When the when the original grantor causes the land to be subdivided and monuments put in place, the common grantor doctrine and also the doctrine of monument both say basically the same thing. When the land is bought with the monuments in view, the presumption is the grantor and the grantee walked the bounds, and the grantor granted, and the grantee was conveyed the dirt surrounded by the monuments. Therefore, the monuments become sacrosanct. And in that situation, the surveyor, the original surveyor, is not an original surveyor because his monuments weren't blessed. And herein lies another problem for retracement surveying. One of these days in that subdivision, somebody's going to come out there, some surveyor is going to come out there, and they're not going to find that monument at one of the corners. And being the good surveyor that he is, he's going to dig down 4 feet until he finds, quote unquote, the original monument, and it's 3 feet off. What do you do then? Anyway, I've gone down a rabbit trail. I'm bringing myself back. Establishing and reestablishing shows that we don't know what we're talking about, because surveyors do not establish boundaries, nor do they reestablish boundaries. If you can't establish one, how can you reestablish one? Or now see this, there's 5 functions. You can do one or any of the others, or retracing. So now, the standardized contract. One surveyor gets the phone call and he's asked to survey. You get that phone call, hey, what's it going to cost for you to survey my property out here? I got so many acres. Here's my parcel ID number. Look it up, call me back. And sure enough, the one surveyor, the surveyor who understands retracement surveying, right here, this guy right here, he's going to call back with one price, just say $5,000, because he knows that surveyor knows what the elements of retracement surveying are, and what that surveyor is going to have to do. That surveyor is going to have to retrace the boundaries on the ground using what's the criterion? Best available evidence. what's the standard of care, what the reasonably prudent practitioner would do under like or similar circumstances. Going to have to go out there and retrace that boundary using the best available evidence that the reasonably prudent practitioner would do in like or similar circumstances, then bring that evidence in, weigh that evidence, and then render a well-reasoned opinion on the only question the retracing surveyor has, and that's the location question. Where's the property located? That's one level of service. When that surveyor calls that potential client back and says that's going to be a $5,000 surveyor, that potential client hangs up, calls the next surveyor, and that surveyor is the only thing that surveyor is intending to do is relocate the boundaries, and it's perfectly legitimate. And that surveyor goes out and does just that, finds a starting point, has a deed, gets an azimuth, and then precisely stakes out the deed, relocating the property boundaries. What's wrong with that model? There's a lot wrong with that model. Number one, it's allowed. Number two, the two surveyors were quoting on the same exact piece of property, and the landowner, the potential client, got a quote for two different levels of surveying effort, but doesn't know it. And therefore thinks that the first surveyor, the retracing surveyor, was trying to cheat him, out of $4,500. And the other guy's the hero. And who's going to get the job? The other guy. So the idea behind a standardized contract would be to get us all on the same playing field. Get us all on this, level the playing field. And the first thing we have to jettison is this ridiculous definition of surveying, which I have brought to the attention of the NCEES. And they don't think there's anything wrong with it. There's nothing wrong with that. You can't see what the problem is. Let me forward. All right, let's try it this way. So there is there's an easy fix. I mean, the fix is so easy, it's ridiculous. Okay, so we have 5 possible things you can be doing as a retracement survey. You can be locating, that kind of sounds like retracement, but it really doesn't spell it out. You can be relocating, moving the boundaries to a new position. You don't establish anything, and if you can't establish anything, you certainly can't reestablish, or you can retrace. So that's what's in the model law. That's what's in a lot of people's law, a lot of states' jurisdictional law on the definition of surveying. But the fix is absolutely, it's ridiculously simple. And I've brought this to the attention of several boards. It's ridiculously simple. All you have to do at the administrative law level, all you have to do, board, engineering surveying board, all you have to do is, and this is your job as a regulatory board, is you take the statutes that are given to you and you apply them to the the rules. And all you have to do, this is so simple, it's sick that nobody will do it. All you have to do, board, at the administrative level, doesn't require legislation, doesn't require convincing any lawmakers. It just requires some brains between the ears, is define what the terms mean. So it would be something like this: the terms locating and establishing refer to an original survey. Even though I completely disagree with the term established, but to get rid of established, you're going to have to go back to the legislature. This could be done at the rulemaking level. Locating and establishing mean you're doing an original survey. And then you define what an original survey is. Delineate new property lines for a subdivision of a parent tract. B, reconfigure existing property lines under common ownership for a new subdivision of property, original survey, common grantor, subdivide a section or portions of a section of land as a part of the public land survey system that is under common ownership where no such subdivision has ever been previously conducted on the ground. The purpose of an original survey is to create an original subdivision or re-subdivision of land under common ownership. So either you're doing that or you're doing that, the next thing. And the next thing is we're going to define what relocating, reestablishing, and retracing means. That means we're referring to a retracement survey of existing property lines or boundaries of any tract of land in order to determine where the property lines have become established on the ground, either through a previous original survey of the property lines being retraced or by the application of the appropriate boundary law principles governed by the facts and evidence found in the course of performing the retracement survey. Where's that language come from? I stole that language out of a document that all of you should know very well. Where in the standards do they talk about appropriate boundary law principles? Has anyone read the ALTA standards since 2011? 2011, 2016, 2021? What are we supposed to be doing? Resolving boundaries based on the appropriate boundary law principles, which gets into a whole other thing. What are the appropriate boundary law principles? But nevertheless, that's language taken right out of the ALTA standards since 2011. Where the standards made it clear that we're resolving boundaries based on the appropriate boundary law principles. And what are the appropriate boundary law principles? We'll have to get into that on another day. A proper retracement survey shall include, but is not limited to, appropriate record field research, gathering and evaluating the best available. There's your surveyor's criterion right there. There's your retracement surveyor's criterion. Best available evidence that the reasonably prudent practitioner would find in like or similar circumstances, the standard of care, which actually takes care of some survey methodology. We've been told that we're supposed to dig and dig and dig and dig and dig and dig and dig until you find that original monument, correct? That's what we've been told. Does that pass muster under American American law? Does that pass muster in American jurisprudence? No, it doesn't. The standard of care for all professionals in the United States of America is what other reasonably prudent practitioners would do under like or similar circumstances. Sometimes it is totally unreasonable and nobody's going to pay you to do it, to dig up the intersection. So this idea that we have instituted and have put upon ourselves doesn't even pass muster under the standard of care for all other practicing professions. Why should we saddle ourselves, and why should we worry ourselves with something that's happened so long ago? So you're probably thinking, okay, well, it's next time when Jeff comes to the Western Federation, we're going to burn him at the stake for saying this stuff. But all I'm doing is bringing the reality to you. The standard of care is what the reasonably prudent practitioner would do. Now, if all reasonably prudent practitioners, and this is a contract issue. I was in Minnesota about 10 years ago at their state conference. And they were having all of their contests. They had their plat contest, they had their boundary map contest, topo map contest, subdivision plat contest, mortgage survey contest. They even had their corner record report contest. And all of y'all know what a corner record report is. The blue ribbon prize went to the county surveyor in such and such county because for 60 years in the intersection, there had been a spike, and for 60 years, and all the titles were hanging off that spike for 60 subdivisions, individual properties, commercial properties, everybody's been using the spike. County surveyor came along and said, you know what? I think that the original sandstone monument is down underneath that intersection. Now, tell me what other reasonably prudent practitioner would be able to do this. So obviously he went to the county commission and he got permission to block off the intersection, get the county road crew out there and start digging the pavement out. And they got a backhoe out there and they started digging. 6 feet down, they found the original sandstone monument, 8.25 feet east of the spike. To what end? It doesn't pass the standard of care. No other reasonably prudent practitioner could do that. You'd have to be the county. Only the county surveyor could have done that. Or it's a contract issue. If that's what you feel that you have to do as a surveyor is to dig up the intersection and go 6 feet down to find that original sandstone, and instead of accepting the ancient and what everybody has blessed, now has become the established section corner. And you go to your client and you say, well, you know, I can't finish this survey. This is a contract issue. This is part of the standardized contracts. This is called your contingency clause. See, this standardized contract can save you from hurting yourself. So no, I've got Walt Robillard said that I have to dig and I have to dig and I have to dig and dig and dig until I find that original corner. And so, well, how much is that going to cost? Well, that's going to, with the road crew and then the repaving and the into the block, about $50,000. If your client agrees to that, fine, go do it. But I don't have to lose my shirt, my business over that corner going out and digging down into that intersection. It doesn't pass. That doesn't even pass the common sense test. And here's where your termination. Okay, so you have a contingency clause in this standardized contract. And the contingency clause is this: we're going to do this job for $5,000. That's, you know, maybe that's even an estimate. And don't forget about getting money up front. Get money up front. But we're going to do it for $5,000. You know, we're going to do this, that, and the other. If we run into unforeseen circumstances, this is your contingency clause, then we will stop work and we will advise. Now, see, this is something I never learned until I became a lawyer, and I went and did this Bridging the Gap 2-day seminar, and they gave us a bunch of CDs with documents on, with different papers, and one of them was just a simple letter of engagement. And one of the things they have in their letter of engagement, all of them, they have a termination clause. Now, I had never even thought about a termination clause until law school, because as a surveyor and a private business owner, it never occurred to me that I might want to terminate a client. No, I want more clients. I don't want to terminate clients. But you need to have you need to have a contingency clause. And the contingency clause basically says, that's our amount of money. But if we run into unforeseen circumstances, we're going to stop and advise. And then we will move forward either under a new lump sum agreement or hourly rates, whatever you want to put in there. And then if the client doesn't take your advice, then you can invoke the termination clause, which will say, if we terminate either for, you know, with or without cause, either party, with or without cause, you want it to be even. You don't want it to be like, you know, you're in control of this contract. You want it to be even. Client can terminate, I can terminate, with cause, without cause. We don't need cause. All we need to do is give notice that we're terminating, and then you terminate. And of course, the termination clause then says, and you know, the surveyor will get paid for those services rendered up into the, you know, notice of termination. Now, does that mean you're going to get paid? No, but it's better than nothing, because if you're doing this on a handshake, if you're just doing this word of mouth, you're guaranteed, if you terminate with that client. And this is why I think surveyors don't, many of them probably don't even have a termination clause in the contract, and the other thing is, this is just Jeff's gut feeling. One of the reasons we have slipshod, undercut, crappy work is because surveyors don't feel like they feel like if they agree to do the survey for $500, dadgummit, they got to do it for $500. That's just not true. Nobody can force you to complete a contract. That's called indentured servitude. We fought a civil war over that one. You can't make slaves out of people anymore. I don't know if anybody knows that. You can't. So now, can they sue you for breach of contract? Yeah, sure. How much are they going to get for $500 breach of contract? It's not worth it. It's not worth it. So but that's my feeling, is that a lot of surveyors, one of the reasons we have a lot of these pincushion corners, multiple monuments in the ground when there's only one corner in legal contemplation, and we get all this slipshod work, is because surveyor gets out there and finds out there ain't no way I can do this for $500. So we're going to have to cut corners. Just go drive in the irons, boys. Let's get her done. It's not having a contract. At least with a contract, you will have a chance of getting your money back. You can go to court. You can go to small claims court. No attorney is going to take your little $500 contract case, because there's, on what, contingency basis, that $500, that's half the that's twice the filing fee, maybe $250 filing fee. Which comes to another point. Why do you need a contract? Well, one of the reasons you need a contract is how much money you're willing to write off. You need to be willing to write off $5, $6, maybe $10,000 if you don't want to work with a contract, because the only way you can get your money back, not the only way, but the only way you're going to get your money back on these smaller contracts is nobody's going to take it on a contingency. But if you have, if you get in a lawsuit and you win, then you get reimbursed your attorney's fees, and other reasonable costs. That's the only chance you have of getting money back. There's 3 ways to get your money back in American jurisprudence. Number 1, if you go to court. So even if you go to court and even if you win, you don't get your money back. It's called the American system. There's only 3 ways. Even if you win, you don't get your money back. Even if it's egregious, you don't get your money back. There's only 3 ways to get your money back in civil litigation in the United States of America. 1 is have a contract. Number 2 is there has to be some legislation or a statute somewhere that allows you to get your money back. Now, here's one no surveyors don't know anything about, at least by and large. Frivolous lawsuits. You can get sued over anything. But if there's a frivolous lawsuit filed against you, and this has happened to me, it's totally frivolous. Most states, and I certainly can't say I've seen this in all states, but I've seen it in a lot of states. Most states have a remedy for that, and it's called sanctions. And so if a frivolous lawsuit has been filed against you, then there's an opportunity for sanctions, and there's a process that you go through, but you can go through that process and you can get your money back if they file a frivolous lawsuit against you. So that's one way. Another way to get your money back. Reverse condemnation is another example where there's a statute that says if you win your reverse condemnation case, you can get some of your money back. And then finally, the third one is a court-made rule, and it says if actor A, because of the actions of actors B and C, has to go to court to defend himself, actor A is the next door neighbor, actor B is your client, actor C is you. And you two get together and trample on the next door neighbor's rights, and the next door neighbor sues for any number of things: negligence, slander of title, trespass, whatever, and wins, then actor A can get their money back. So there's only 3 ways, and a contract is one of them. All right, best available evidence. If necessary, interviews with local landowners familiar with the property boundary lines in the community, and reporting these findings on an appropriate map of survey indicating the corners and the lines retraced, the monuments found or set during the course of the survey, and an explanation of the boundary law principles employed by the surveyor making such determination. Any survey of property includes setting or resetting of appropriate boundary monumentation unless appropriate monumentation already exists. That, in essence, is a standard of practice, which nobody has in any jurisdiction. And how many paragraphs was it? That 1, 2, 3, 4. We'll call that a paragraph, even though it looks like a sentence. 5, 6, 7, 8, 9, 10, 11, 12. In 12 paragraphs, I have defined what it means, the standard of practice for surveying in the United States of America. What is a standard? A standard is a model. It's a model of good practice. It's a model of perfect practice. Nobody's going to be perfect, but it's a model. And you may not ever reach that model in your practice, but we're striving for it. Everything else that I've seen across the country in the various jurisdictions are a bunch of technical standards that they put some lipstick on them and they call them standard practice. None of them describe what it means to survey property. Anyway, this would do it, and it would solve a lot of our problems. Number
Jeff,
one,
I hope you're talking about this at the conference coming up at the end of March.
well, somebody asked me the question, and I'll go down a 45-minute rabbit hole if I have. There is one other definition we need. There is a need for a survey that deals with property boundaries, but does not make property boundary determinations. So that would be called a forensic survey. So in my world, in Jeff's world, it would be you're either an original surveyor, or you are a retracing surveyor, or you're doing something else. And this is the something else. I couldn't find a definition for this, so I had to make it up on my own. Don Wilson has a book called Forensic Surveying. He doesn't describe what forensic surveying is. The forensic survey is the application of surveying science to the elucidation of questions before courts of law and equity. Forensic surveys are not boundary surveys, and as such, no opinions are given as to the status of the property lines or property corners, nor are property corners established or reestablished as a result. The most common utilization of forensic surveys is for courtroom exhibits to advance legal theories to support facts to be proven and to buttress expert witness report. And the most common thing that this would be used for would be adverse possession cases, because the adversely possessed property is potential property. That line between the adversely possessed and the adverse possessor is a potential property line, and in my opinion, will not become a property line until you get your court adjudication. Now, I know you've probably heard a lot of people, maybe well-respected people, say, well, when all the elements of adverse possession are in place, title automatically passes. Well, one question that nobody can ever seem to answer is, well, how does that pass muster under the statute of frauds? The statute of frauds says land cannot be conveyed without a written document. Adverse possession is a conveyance of land. It's a conveyance of land. And you get your adversely possessed land when you get your adjudication, and your court ruling is your written document. Now, there is an exception to that, and that would be if both properties have color of title over the overlapping land. Now you got color of title, but see, the thing is, it might not even be, that could be a junior senior rights issue. Which came first? But see, here's the problem with these boundary doctrines and with all of these other title issues that we can't even get into right now, and title insurance companies and all that, all that crap. Here's the problem. The attorneys don't understand the difference between titled property and where the property is located on the ground. Therefore, when they go into a boundary dispute case, which could just be a factual case of location, well, junior senior rights where we got overlapping areas, that's a factual, that's not a title doc, that's not a title fight. That's a factual question over which can, who was conveyed the strip of land first. Or it could be something else. But anyway, so the attorneys, when they have a boundary dispute case, they try to turn it into a title fight. Unless you're arguing adverse possession in any boundary dispute case, any boundary disputes, it's not unless you're arguing the title, it's not a title fight. It's not even a legal question. It's all factual questions. Boundary disputes are factual questions. That's why the court has to have equity jurisdiction, because equity isn't the law and the law isn't necessarily equitable. But anyway, we could go on and on and on and on about that, but I'm not going to do that. What we're going to do is do a new share and get over to contracts.
There you go. Yep, your PowerPoint's up now.
All right. So there you go. This is what happens every time you have me on, Trent.
You're good. You're good.
It's called diarrhea of the mouth.
You're passionate about NCES. I know that for sure from all of your presentations.
All right. So anyway, so we'll just hit a couple of things here on contracts, unless somebody unless you want to do some question and answer. But
we'll hit the important stuff, and then we can ask some questions
okay.
or something. So yeah, perfect.
And one of the things I'd always say is know the law that governs your practice, and that includes knowing contract law, knowing, like you said at the very beginning, Trent, knowing what your statutes say, knowing what the board's rules are, adhering to those board rules. Those are ultimately very, very important. Ignorance of law is no excuse. Have a written contract. Now, one of the reasons I even created this program was to make it so simple to have to have a little one. And this is what I learned from the attorneys. They don't have these monster contracts, 3 inches thick. They have the letter of engagement they gave me in that program that I took right out of after passing the bar was a 1-page letter of engagement. So we're going to get to that really, really quickly. Contracts, oral contracts, indemnification, element. Here are the elements. What we need is an offer. Basic elements of a contract. We need acceptance, a legal purpose, subject matter. It has to be legal subject matter. Consideration. It's not a contract without consideration. This is different than a contract and deed. Legal capacity. You gotta be old enough to enter into a contract. And execution, although we could talk about that. Actually, a contract can become valid even without the parties executing the contract. There's case law behind that. So anyway, here are your essential elements. Now, these are things that you want. Project identification. You want to spell out what the standard of care is. You don't want that being determined in court. You want it in your contract. You don't want some, he guaranteed. He warranted the results of the survey. Now we're going to spell out the standard of care. Tell them what your deliverables are going to be and how many you're going to give. That's kind of gone out the window these days too. Give them an idea what the schedule is, what the payment terms are for sure, what the applicable law is going to be. If you're licensed in several states, if you're working in those states, where do you want the law to be? The state where you reside. Attorney's fees, you want your money back. Attorney's fees, there's contingency clause, additional services. Make sure the offer expires. But if they don't sign your contract after a certain amount of time, make sure it expires. Termination clause, statement of warranties. We give no warrant. There are no warranties, no guarantees. No, that is not us. Here's your optional elements. Put together your essentials with your optionals, and then you get a one-page. You can get a one-page contract. Here's your offer, acceptance, acceptance, project identification, legal purpose. Here's who it's addressed to. Here's a project identification. Project identification is here. Here's how we're communicating. Letter of engagement. This is your offer, accepted, project identification, legal purpose. We're a surveying company. We're offering surveying services. Execution list letter will accept and confirm our acceptance. You can force acceptance by signatures by saying your contract isn't valid without the signatures. But if that's kind of left up to the imagination, courts can get pretty imaginative. Subject matter, standard of care, and what I'm going to deliver. Consideration, schedule, payment and terms, applicable law, and attorney's fees, all right there. And late fees too, 1.5% per month. That's right below usury, 18% a year. 15, tell them when it's due. This due date isn't a guarantee. A reasonable effort. In the event collection proceedings, Alabama law will apply. Unforeseen circumstances. Okay, here's my contingency clause. Unexpected difficulties. Client will be consulted before surveyor proceeds further. If additional services deemed necessary, surveyor will perform those services. I'm going to do an hourly rate. You can do whatever you want to, not another lump sum. Surveyor will only perform additional services with written or verbal. Don't get caught with that one. All these contracts say only with written authorization, and they, you know how it is. They're begging you. Oh, come on, man, come on! I'll sign your contract. I just need you to get out here and do this work, right? Until it comes time to pay. No, your contract says written or verbal, but of course, what you're going to want to do, even on a verbal, is you want to send something. You want to send a fax. You want to send fax. What am I talking about? Who has a fax machine anymore? You want to send an email, maybe even a tweet, something. And then what's going to happen, either party may terminate with or without clause, and upon termination, surveyor will reimburse for services performed. No guarantee, no warranties, express or implied, and person signing below certified that they have legal capacity. Got it caught in this one time, working for doing some attorney work years ago for an engineering and surveying firm, and they owed them $10,000, and they got out, and so we were taking them to small claims, and they got out because the guy who signed the contract was the contractor's brother-in-law. He didn't have legal capacity, so that was going to be their argument. So that took $5,000 off the claim. They cut it in half with that one. But anyway, and could we have gone after the brother-in-law for fraud? Yeah, we could have, but it just wasn't worth the effort. And then everybody signs. One thing I do want to talk about real quick, we'll just park it right here. You don't even really have to have a signed contract. And especially a signed contract by both. Now, here's how you do that. It's called a letter of understanding. Now, I will give Nude Hermanson the credit for bringing it to my attention, but it's pretty common. Okay. And here's how, even if you, Okay, so you don't even want your client to have to sign a contract. I know the feeling. Okay, I was a small businessman myself for a long time, and I didn't want to run clients away. But we've been, just because I have a contract doesn't mean that I'm going to get paid. I can get paid just as well on a handshake. That's fine. There are other benefits to having a contract, such as personal protection, corporate shield. If you're going to sue me, client, the most likely person to sue you is going to be your client, and you can have your client agree that if y'all get in a tussle, the client under contract will have to sue the company and not you. So you do things like that. Plus, you can get your money back if you have to go to court. It's a possibility you can get your money back. Let's just put it that way. Without a contract, you have no possibility of getting your money back. So I don't even want to have my client sign it. So what you do is you take this basic language here, you get yourself a stock email, you put it in a Word document, just pull it up whenever you're ready to send the email, copy and paste, ship it off. The key to and it's called the letter of understanding. The key is, well, first of all, you're going to identify the project. You're all those essential elements. You're going to identify the project. You're going to identify the services. You're going to identify the fee. You identify the law. What state, what jurisdiction you're going to be in. And then at the end, you say, if this is not in bold, big bold, if this is not our complete understanding, or time is of the essence. If this is not our complete understanding, you must contact us within 48 hours of receipt of this email, fax, text, whatever it is you're sending. And of course, if you're sending an email, you want to get a response back within 48 hours, or this is a binding contract. That will hold up in court. That will hold up in court. Now, I got involved in a contractor land surveyor dispute a few years ago, and the contractor hired the surveyor. The site contractor hired the surveyor to come out and do various and sundry things, and they sent over an unsigned contract to the surveyor, and the surveyor sat on it, but they started working. And they went out and they set the stakes in the ground, and then the contractor came in and they started pouring concrete, putting the curb in, or putting the storm sewer in, putting the sanitary sewer in. Both parties started acting as if they had signed the contract. And then of course there's a problem. There's a problem. And of course it has to do with the architect. The architectural plans and the engineering design plans had the building 10 feet different, and the surveyor took I think the engineers, whichever one had dimensions on it, took the one with dimensions, and they used the dimensions, but it was the other one that was supposed to apply. And anyway, they were going to get into this big tussle. Of course, what ends up happening is the insurance company comes in and pays, and everybody goes on their way. It's all about money. That's why you don't read about those cases. Generally speaking, because it's a business decision. At that point in time, it's a business decision. But one of the things I was harping on was, well, they never signed the contract. Well, turns out, especially in Florida, that's where it was. You don't necessarily have to have signed contracts. It was the actions of the people. The parties acted as if they did sign the contract. And therefore, what did they have? A meeting of the minds. And what is a contract all about? A meeting of the minds. That's why both parties are supposed to, under textbook contract law, are supposed to sign. That's the proof that they had the meeting of the minds. They both signed it. So that's that. All right, Trent.
No, you're good. That was totally fine. Yeah. I had thrown in a couple of things like Nevada. So Nevada has a written contract. You're not allowed to start work until you have a written contract in place. That's based on our administrative code. Rob just threw in California's business and practices code as well for their written contract. So again, like we kind of talked about in the beginning, definitely not, I don't know if Nolan is on, but I think still available or not. But I know some of the other states are just now starting to require written contracts. Now we're 2021, 2022, where we're just starting to do some contract clause. So, and I believe there's states that still don't require it. So
I think an Alta survey is, I think it's part of the Alta requirements that you have a contract, right?
that is a great question. We'll have to
I
look that
think
one
it
up.
is.
I would imagine, yeah. We'll have to look that
Yeah.
one up. But that's a good point. So anybody
Well, let me ask you a question, Trent.
Go for it.
Let me ask you a question. So in Nevada, the requirement for a contract just says you got to have a contract. It doesn't specify anything about the contract.
No, it does. In our NAC code, it does, and it specifies I threw it in the chat. So the written contract must include, without limitations and provisions, specifying the scope of work, the cost for completion of work, and the anticipation date for completion of work. Those are basically just our three kind of contract items that must be addressed in that contract. So
Yeah.
And for California, there are 5.
okay.
A description of the services to be provided, a description of the basis of compensation, name, address, and license certificate number of the surveyor or civil engineer, description of the procedure to accommodate additional services, and how to terminate the contract.
Okay.
Termination clause. I love it.
Yeah. That's a good one. That would be maybe one to even present to our NALS board. Our Nevada board.
California Land Surveyors Association has a single sheet contract, which is actually a front and back of I believe it's a legal sized paper that we have on in a pad format that our members can order, and you just fill it in and just write in your descriptions and that sort of thing. And so it makes it real easy to have these contracts where you go and look at a site, meet the owner on site, and get the description of what their needs are, and fill out the contract and do it right there and say, all right, I'll fax you a copy of this, but I get back to the office in 1995.
There you go. Carl in the chat has a great one. Is receipt of a retainer adequate proof of acceptance if that is what the transmittal says? That's a good question.
I think that's I think that's pretty solid right there. Money's passing hands already,
Yeah. Cash to retainer check. Yeah. Good question there, Carl. Anybody else have more specific questions or that they're kind of dealing with on the contract side that was want to bring up? Josh, you got anything? Josh, you've been dealing with contracts for a while now. Nothing new?
No, not really. I mean, I try to make sure I include the termination clauses. I give time limits on receipts. I do a lot of the I call them letter of understandings. I do those on smaller projects that are kind of my cookie cutter projects, but I'm a firm believer that it needs to be clear and in writing, and both parties need to understand. And so far in 28 years, haven't had any problems.
There you go. Is it Georgia law for written contract? No. Okay. Yeah. See, I was curious. Let's see, Jeff. To piggyback on Carl's question, is it recommended to get a retainer? And I think you kind of highlighted that in the very beginning, Jeff. Definitely. I haven't found this to be very common in Texas, and I don't know about even Nevada. I think again that goes back to surveyors and kind of our business models, not so much anything other than surveyors and businessmen maybe not taking retainers.
My anecdotal evidence traveling across the country is that's something really only a few that I know of are absolutely insisting upon.
Yeah.
Most people, most companies we'll work under a contract, but and then hound dog it, invoice early, invoice often.
Right.
And if it's not gonna, and another, it's a litmus test too. If they don't want to pay a retainer, how ambitious are they going to be to pay your invoice when it shows up?
Yeah. I'll jump to Tyler has a good one. Is there anything you see surveyors put in their contracts with good intentions that actually end up hurting them? That's a good question. That's a good question, Tyler.
Well, yeah, I work for a larger company now myself, and we have some stuff in our terms and conditions that I think are totally irrelevant, but they don't ask my opinion. I think the biggest thing is just getting to the point where the client gets turned off and doesn't even want to read the contract, doesn't want to sign the contract for sure. I had this as an attorney a few years back. I hired a surveyor for a landowner who I was helping out on a purchase. So I said, we need to get a surveyor. So we hired this guy, and this is in Alabama. He knows I'm an attorney. I don't know where he told me he had some attorney write it up for him, but he came back with this 4-page contract for doing a boundary survey. And when I read it in the terms and conditions, it sounded to me like he was just, the whole contract was so that he could sue my client. It was just worded that way. And I called the guy up and I said, really? Who wrote this contract for you? I wouldn't sign this if you were the last surveyor on earth. He said, well, I don't know. I just had this guy write it up for me. I said, well, I'll tell you what, you could probably just, do this on a handshake, and I'm pretty sure you're going to be all right. I think you're going to get paid. And that's what he did. So.
Nice. Very cool.
We just lost part of our international connection.
Yeah, Peter jumped off.
Another thing I would tell you for sure is what to watch out for is our indemnification clauses. If you're signing somebody else's contract, you read that thing carefully. I don't like them personally. When I was in business for myself, I struck them out, because all an indemnification clause is supposed to do is articulate the remedies you would have if you went to court under basic contract law. And if they didn't want to strike it out, then I would tell them, then I want the same identical indemnification clause for me in that contract. So here's yours, and this one will be mine, and it's going to be identical to yours. And I can't remember a time when anybody wanted to do that. They just wanted to go ahead and get rid of their indemnification clause. That's easy for you to say, right? Indemnification.
Yeah, exactly. I was going to, along those same lines, do you have any subsequent language to replace the warranties and the guarantees? Have you kind of?
There are no guarantees. There are no warranties.
Yeah. Cross it out.
We're professional service providers. We cannot. That's why we have errors and omissions. And a matter of fact, I believe by making guarantees and warranties, and I'm not an insurance expert. It's been a while since I've read an insurance contract, but I think you can nullify your errors and omissions insurance by making guarantees and warranties.
Yeah, and that's the same kind of language we use as well when somebody wants us to sign it. We like, if you want us to void our E&O insurance and then have no parachute for you, then
right.
Yeah, then we can sign it. But,
yeah, we'll sign that, but we won't have any insurance.
Yeah, exactly. Sean put in the chat, great information. Any sources for future newbie PLSs can get advice on writing contracts, books, or anything like that? Anything you suggest?
The insurance companies, if you're new, get yourself a errors and omissions insurance contract. It probably won't cost you all that much, and they send you all kinds of information. I think they send you form. At least when I first started out, I got errors and omissions insurance. They sent me a booklet. They actually sent me a workbook, to work through. And I forgot what I don't know if it was CNA or somebody like that. Anyway, they sent contract documents. Also, NSPS still has, I believe, a contract guide on their website. I believe they used to have. I know that for sure. Because I have a copy of. They used to have that. The worst, I think, the worst thing you could do, and a lot of even sophisticated supposed clients do it. They will cobble together language from various and sundry contracts that they've gathered up, over the years, and then when you put it all together, it gets self-contradictory. Had a contractor we were suing. A homeowner hired me. It was basically a contract issue, and this contractor had cobbled together such a terrible contract that I thought we were going to really be able to go to town on them, but my guy basically settled. That's another thing, you think you got a winning case, and then you run out of money. So right doesn't always win. Might, especially when it comes to money, often wins. But yeah, cobbling one together, you'd probably be better off, finding one on Google. But it needs to be a professional services contract, and that's what they did for us at that bridging the gap thing. They gave us a basic letter of understanding, form, written agreement that we could use, which opened my eyes. It's like, wow, I thought the attorneys would have, a contract would be like a book, and all the fine print. No, they're pretty straightforward with it. Matter of fact, I've hired attorneys I hired an attorney down in Florida on that frivolous lawsuit. All we had was email exchanges back and forth.
Yeah, I just looked on while you're chatting there. I looked on NSPS. I didn't see anything, but obviously they have the relationship with the Assurance Risk Management, which is the insurance firm that they is one of the sustaining members. So I'm sure.
I bet they have some insurance.
For sure. Yep, for sure. So
because they don't want to pay out, they want their clients to be knowledgeable. They don't want to pay. The last thing they want to do is pay.
Yeah, it's cool. Perfect. Anybody else got any more specific questions? If not, I know Jeff said he's got his grandkids waiting at the house, and it's dinner time in Alabama.
Well, no, right now it's my bedtime, Trent.
Now it's your bedtime. All right. And then, of course, anybody, obviously come out west if you want to see Jeff. There's a great lineup. I know Jeff's, you got a few, I think you're doing Washington as well. So there's a few West Coast conferences. So he's all over running the conference circuit as it is right now, coming up this springtime. So
looking forward to meeting some of you guys out on the road. And thanks again, Trent. Let's do it again sometime.
I appreciate it. Thank you for your time.
Hey, Jeff, do you have a beverage of choice at the conference? Some of us tend to like a little single malt scotch. I know others like things like Bombay Sapphire Gin.
I'm just a plain Jane guy, Maker's Mark works for me.
There you go.
I got some friends that like the Makers. All righty. Be sure to
I'll have a bottle for you.
All right, great. Sounds good.
Awesome.
All right.
Thanks,
you guys
Jeff.
have a good evening.
Appreciate it.
Hey,
Thanks,
Jeff.
Yeah.
Jeff, if you're still there, one thing I just want to say, I want to thank you. The Lucas letters, I have no doubt, helped me pass the exam. And anybody out there listening, the Lucas letters, great subscription, sign up, whether licensed or not, a lot of great information.
That's awesome.
Mark, your check's in the mail, buddy.
I love it.
Thank you.
Awesome, guys.
Jeff, thanks for a good presentation. Lots of good things to think about. And Trent, sorry I was so damn quiet this time.
I know. See, it's all good. We appreciate it. Awesome, guys. Have a good night. Bye, guys.